Like ved Kanariøyene på Afrikas fastland lar Europa sine egne kortsiktige interesser gå foran prinsipper om menneskerettighet og fred. Velkommen til SANDFAST, vår podkast om Vest-Sahara, den siste kolonien på det afrikanske kontinent. Ser man på okkupasjon av Vest-Sahara gjennom briller av realpolitikk og i lys av at Marokko har viktige venner i FNs sikkerhetsråd, virker Vest-Sahara-spørsmålet komplisert. Men hvis man tar av seg disse brillene og ser på saken i et folkerettslig perspektiv, fremstår den betraktelig mye enklere. Løsningen handler om rett og slett å høre på de saharawiske folkets ønske, både om territoriets fremtid og om hvordan de vil at naturressursene skal brukes. Dagens gjest er Manuel Devers fra Frankrike. Han har i et 10 år spilt en nøkkelrolle i det rettslige temaet til frigjøringsbevegelsen Polisario. Det arbeidet har hittil ledet frem til 5 dommer i EU-domstolene. I slutten av september i år vant Polisario det som er den tydeligste seieren så langt. Aldri har domstolen vært tydeligere på at EU ikke kan drive business i Vest-Sahara under marokkanske avtaler. Manuel, welcome and congratulations with this latest victory in the EU court.
Hello, thank you very much for your invitation.
So, tell me, Manuel, you have been working on this matter for quite some years now. How did you yourself end up working on the Western Sahara issue?
Yeah, well, you're absolutely right. We started the first Polisario cases in 2012, so almost 10 years ago. And before getting involved in Western Sahara, we had already some experience, our law office, on other situations of occupations. And so we worked a lot on the issue of imports from Israeli settlements into the open markets. And we got involved in Western Sahara because at that time we used to work with syndicates of French farmers called the Confédération Paysanne. And they asked us to do litigation in France regarding the product of the settlements. And during one of the meetings, they told us, well, actually, you see, we have the same issue with product coming from Western Sahara. And so that's how we got involved into Western Sahara. We discovered actually the great report from Western Sahara Resources Watch on the tomatoes and all the agriculture there. And at the same time, about the same time, the European Parliament was working on the 2012 liberalization agreement. That is an agreement additional to the EU-Morocco Association agreements concerning especially agricultural products. And at the time, the rapporteur in the INTA committee was the committee within the European Parliament in charge of dealing with commercial issues, was José Bové, a member of that French syndicates. And this is how, at that time, he was really trying to resist to the agreement. We got in touch with him and then with the Polisario representation in Brussels. And we started to work on potential cases or things at least could be done. And one of the options that we raised was actually that the fact that the Polisario Front, as the UN recognized representative of the Sahrawi people, would be able to go to court directly to challenge the agreements.
This is a victory. And why this is a victory? And before you answer that, Manuel, could you give a brief introduction to the case?
Well, regarding the case, in 2016, we had the first court ruling regarding the association agreements. And then there was a second ruling in 2016 based on the same principles. Before these rulings, the practice of the Commission was to conclude agreements with Morocco. Then that would be de facto applied to occupied Western Sahara. So what means de facto? It means that in the agreement, there is a territorial clause that is defining the territorial scope of application of that agreement. and that territorial clause only referred to Morocco. But there is a question, an ambiguity that the Commission worked on. Does that mean Morocco according to international law, so without Western Sahara, or Morocco according to Moroccan domestic law, and so including the so-called southern provinces? The Commission always worked on that ambiguity, justifying the application of the EU agreement with Morocco to occupied Western Sahara by saying that's only de facto application. That de facto practice has been a huge problem for the self-determination process of Western Sahara because it has empowered Morocco in its occupation of the occupied part of Western Sahara. And so Morocco was in position to obstruct the self-determination process because of the EU involvement. And so the first stage of the cases, so basically between 2012 when we started and 2016, was really to challenge that de facto application. And so when we started on Western Sahara, everything was disputed. The territory was disputed, the status of the Polisario front, and even the very existence of the Sahrawi people, because people were saying that's not a people, that's a local population. So as to include Moroccan settlers, but as to exclude also the refugees in the camps. And the first stage of the cases was really to clean up a little bit the mess, if you want, and to put the legal categories right. So to force the Commission to acknowledge the proper status of Western Sahara under international law, to acknowledge the status of the Polisario Front, to acknowledge the status of the Sahrawi people. We got that in 2012. In 2016, once we got the first ruling from the court, everything was very clear. The EU could have agreements with Morocco, but not applicable to Western Sahara. So that was the end of the de facto application. But instead of complying with the ruling, the Commission started a process to explicitly extend agreements concluded with Morocco to the occupied part of Western Sahara. So basically, you did not want the de facto application, then you'll get the extension process, the de jure extension. And so the core case is now, and the ruling we just had, was about that extension process. Namely, under what conditions the EU can extend to occupied Western Sahara agreement concluded between the EU and Morocco.
Yeah, I mean, you just answered actually the question that I had prepared, and that's this is the third time the Polisario wins against the EU in the EU court system. And I mean, what were the different cases, very briefly, which you have actually mentioned a bit, and why this is one is different. So you can actually go into the content of the ruling.
So, as I said, we started in 2012 to challenge that liberalization agreement, so that extension to the EU-Morocco association agreement. We got the first ruling in 2016 from the European Court of Justice, the Great Chamber, which is the highest court in Europe, if you want. And the court ruled on two key aspects. The first one, the court ruled that because of the right to self-determination of the Sahrawi people as a separate and distinct status from Morocco. So what does it mean? It means that Morocco and Western Sahara are two different countries, but also the recognition of the separate and distinct status refers to what we call the territorial component of the right to self-determination. You know, maybe you're aware of that already, but I think that's good to clarify that. People with the right to self-determination and independence under international law have actually four rights. The right to determine their political status, that is really the one under the spotlight in Western Sahara, but also the right to territorial integrity, the right to the respect of their national unity. So basically, you should refer to the people of Western Sahara as a people, not just as a population. And then the fourth component is what we call the permanent sovereignty over natural resources. So four aspects of the right to self-determination are totally intertwined, and that's not possible to respect one aspect and to violate the other ones. So if you start to interfere with one of the four components, you're actually violating the entire right to self-determination. And so the first aspect, the first thing that we got from the court in 2016 was the recognition of the separate and distinct status of Western Sahara. So the territorial component of the right to self-determination, that has two implications. First, a technical one in the sense that Western Sahara and Morocco are not the same thing, but also a more fundamental aspect. Because the territory belongs to the Sahrawi people, it cannot be a Moroccan territory. There cannot be Moroccan sovereignty over Western Sahara. The separate and distinct status means two things. The territory belongs to the Sahrawi people, then because of that, it cannot belong to Morocco. So that's the full meaning of the separate and distinct status. The separate and distinct status was something that we knew already because we had the previous advisory opinion from the ICJ in 75. But in Western Sahara, and as in other many, other occupations like that, we saw the occupiers, we saw also the allies of the occupier try to dilute the legal terms and to develop that idea that Western Sahara somehow was disputed because Morocco was able to block the political process. The answer from the court is very clear. Western Sahara is not disputed. It has a separate and distinct status from Western Sahara. The status is very clear in the international law. And I must emphasize also that during that case, we also refer to the borders. There are actually, little people know about that, but there are treaties that were concluded between Spain and France back in time when they were the colonial power of Western Sahara, when they decided to define the international borders. And so not only Western Sahara has the right to has a separate and distinct status, but it has internationally recognized borders with Western Sahara. So that's the totally opposite to a disputed territory. So that's the first aspect, if you want, which is from the court, a reminder of the applicable law. The second thing that is even more interesting, and that is really the key and the breakthrough at that time for the Sahrawi people, is the fact that the court ruled that the Sahrawi people is a third party to EU-Morocco relations that must consent to any agreement applicable to Western Sahara. Before the ruling, the only legal opinion that existed was the opinion delivered by Hans Corel, who's the legal advisor, if you want, if I simplify it to the council, that made a legal opinion regarding the possibility for Morocco to sign contracts to exploit petroleum, on the offshore of Western Sahara. At that time, the opinion was delivered in 2002 for the Security Council, with states that were pro-Sahrawis, other states that were pro-Moroccan, so very divided. Also from the perspective of the legal advisor is to explain broadly the applicable law, but is not to decide instead of the decision makers. And so he delivered an opinion where he explained that somehow the exploitation of the natural resources by Morocco would be possible if that was beneficial to the Sahrawis and in accordance with their wishes. I really want to emphasize that at the time, the applicable law was less clearer. For instance, in 2002, there were still discussions as to whether Palestine is occupied according to international humanitarian law. We only got the answer from the ICJ in 2004. And so when he delivered his questions, there were many questions with no answer on the exact status of Morocco in occupied Western Sahara, the exact status of Western Sahara under international humanitarian law, which may explains why also the legal opinion was criticized after that. But the Commission used, or misused, I should say, the Corel opinion that was clear on the wishes and so the will of the Sahrawi people to emphasize the benefit effects. And so the Commission started to explain that de facto application that I referred to was possible with agreements concluded between Morocco and the EU. So this agreement could be applied to Western Sahara if such an application was beneficial, not to the Sahrawi people, but to the local population, which is a way to allow everything, because what is development? What does it mean beneficial? Beneficial for whom? How do you measure if something is beneficial? And so the Commission developed that argument to justify actually the illegal involvement of the EU in the occupation of Western Sahara. With the ruling of the court, and that's really why the 2016 ruling is so powerful, the court clarified that the only legal criteria that is applicable is the consent. So it doesn't matter whether exploitation is beneficial or not. The question is, did the Sahrawi people agree to the inclusion of Western Sahara, of their national homeland, their natural resources, in a trade deal with Morocco?
Yeah.
And to reach that conclusion on the consent, and so that position of the Sahrawi people as a third party to EU-Morocco relations, the court relied on two aspects. First one, the Sahrawi people have the right to self-determination and independence. So you cannot compare the Sahrawi people with an indigenous community in an existing state. That's people with the right to self-determination and independence. The second thing is that the court said, well, that people has a representative recognized by the UN. That's the Polisario Front. And so basically, you've got the two elements that are decisive for the consent, a beholder of the right to consent, and a body able to express the consent on behalf of the Sahrawi people, that is the Polisario Front. So that's really the result we got in 2016. And quite frankly, the court, if you read it in good faith, and all our professors, not only us, understood the ruling in the same manner, that's very clear. If the EU wants to have agreements with Morocco, or if it wants to have agreements applicable to Western Sahara, they must get the consent of the Sahrawi people through the authorization of the Polisario Front. And there, again, when you look at the practice of the EU, there is a very clear precedent, because the EU has already a trade agreement with Palestine, concluded by the Palestinian Liberation Organization on behalf of the Palestinian people. And when you look at the ruling, the court refers actually to the situation of Palestine. So that was really clear at that time. But real politics, or whatever, actually, I don't know, the Commission decided to engage in that extension process that I referred to, in violation of the court ruling, by saying that basically the consent of the Sahrawi people could be presumed if it was possible to demonstrate benefits. And so that's why, after the ruling of the court, the Commission worked on the technical aspect. So if you're on drafting the new agreements to include Western Sahara, and then it started a so-called consultation process to demonstrate benefits. And the stakeholders that were consulted were only basically Moroccan stakeholders, depending on Morocco or the Moroccan government, with obviously the view that the agreement was beneficial. But therefore, that was clear that regardless of the way the consultation process was conducted, the very principle of the consultation was illegal, because you cannot get the consent of someone only by doing consultation. And so that's why the Polisario Front decided to go back to court and to challenge the two new agreements, to challenge the very fact that the Commission could not use consultation to get the consent of the Sahrawi people.
So just to make conclusion for people who are listening, so despite actually the fact that you won a case, or the EU court was very clear in 2016, the Commission in a way didn't care about it, or instead of respecting actually that decision and implemented it, the EU Commission decided to continue with the trade with Morocco, or with the agreements with Morocco.
Yeah, that's very clear. They wanted to save the agreements by circumventing the ruling and by misinterpreting the criteria that were set forth by the court that were very clear.
Yeah. And as you said, the consent is not the same as a consultation. And that's why the Polisario decided to go again for a case.
Yeah. And so, but the things that I want already to emphasize is that in 2016, for us, all the job was done in the sense that if the Commission had a good faith interpretation, it would have stopped the involvement of the EU in occupied Western Sahara, or it would have approached the Polisario Front to engage in negotiations. The other thing also that I want really to underline is that the process between 2012 and 2016 was about, getting the recognition of the rights of the Sahrawi people under EU law. So 80% of the job, in a sense, was done already in 2016. That's why when we went back to the court with the Polisario France, that was not about to discuss anymore whether consent was necessary, whether the Western Sahara had a separate distinct status, whether the Polisario Front was the representative. The only question is that, is it acceptable under international law or under EU law to do consultations, to prepare an assessment, an impact assessment, to replace the consent of a sovereign people that is a third party to the EU-Morocco relations. The thing, when we started the case, is that we had the 2016 ruling. You mentioned a second victory, that was the 2018 case. The scenario there was a bit different because it came through a preliminary ruling from UK courts. Under the system, the legal system of the EU, national courts can refer questions of EU law to the European Court of Justice because the European Court of Justice has a monopoly on the validity, the interpretation of EU law. And so a solidarity group there, Western Sahara Campaign, started another case on the fishery partnership agreement that was referred to the courts. And the court, when it got the case, it said, well, but basically I said it all already in 2016. Separate and distinct status, consent. And so what applies for exports of agricultural products or for export or trade agreements applies equally for fisheries. And so the EU-Morocco fishery partnership agreement cannot include Western Sahara. So we had already that body of case law that were later on, and that's very interesting, used by the court in the case of Palestine regarding the labeling of settlement products, where the court referred to the recognition of the separate and distinct status of Western Sahara under EU law to say that Palestine, due to the circumstances, has also a separate and distinct status. Mm-hmm. So the core of the applicable law, the two principles that I referred to, separate and distinct status and consent, they're very clear. The second case, the new cases of the Polisario Front, was really about the technicalities, so the 10% that were remaining, if you want.
Thank you very much, Manuel, and thank you for everybody listening to this episode. In the second part of this episode, we will continue speaking about the details of the court decision, the specific details like the consent with the benefits, about the Polisario as a representative to the Sahrawi people. Hvis du vil lære mer om konflikten, gå til vest-sahara.no.